punch card ballots and optical.
I do agree that the specific problem that troubled the Supreme Court in Bush versus Gore, and that is that you had human beings applying inconsistent standards to the counting of ballots.
That was one of the problems.
That problem does not exist in California.
Well,
certainly not in this case.
That's right. When I looked at the detailed rules in California, when it comes to the very end, when it says if it's ambiguous, then we're not quite sure what you do. You look at the intent of the voter. So I think we are fooling ourselves if we imagine that California has outdistanced Florida in a fundamental way. But the real point that disturbed the Supreme Court in Bush v. Gore with respect to what was happening was not only human beings, it was that there were demonstrable differences. In some counties, overvotes were counted, in others they were not. And it was the fundamental fact that there was not in place any sufficient safeguard to make sure that every person's vote counted the same way.
What do we know about the error rate of the Inca vote system that LA County intends to use in March of 2004?
We only know that the Secretary of State has certified it as acceptable and is apparently satisfied that because it works like the punch card ballot, except that you don't have the problem of hanging chads or dimple chads, you use the familiar pen, it is expected to be more user-friendly and more accurate.
But you do have the same problem with overvotes and undervotes because there's no, as I understand it, precinct scanning.
Yes, Judge Tashima, some of the problems persist in Los Angeles.
We don't know the degree to which that's going to differentiate that optical scanning system from the...
But we do know this, and I think this is quite important when we are dealing with a matter of such great moment. We do know that the Secretary of State of California, who is charged with determining on the basis of the best information known to him whether a form of ballot is deficient or outmoded or otherwise unacceptable, we know that that determination has been made favorably with respect to the techniques that will be in use everywhere except in these 6 counties. And so the question of law presented is whether it is consistent with equal protection of the laws, not just the way...
Are you suggesting that best available technology then becomes the standard in these electoral challenges?
No, certainly I don't think so, Judge McEwen. And the reason is that we are not suggesting that perfection is important. We are suggesting that when the state has in place a mechanism for deciding what is unacceptably poor, not up to snuff, what is unacceptably poor, not up to snuff.
I didn't turn on the TV for the election results, and I didn't turn on the radio. Instead, I sat here filling out 3,000 Freedom of Information requests to go to every county in the United States to obtain the internal audit logs of those computers, knowing that we couldn't get them for weeks after the election, and that it would probably be certified and they would say, get over it, move on. And we would never know whether our election was controlled by 100 million voters or by one guy sitting in his grandmother's basement.
Black box voting needed the logs of all activity on the voting machines so that they could conduct an investigation for the people. They wanted the vote count to be independent from partisan politics.
In America, it is vital that every vote count and that every vote be counted. But the outcome should be decided by voters, not a protracted legal process. I would not give up this fight if there was a chance that we would prevail. But it is now clear that even when all the provisional ballots are counted, which they will be, there won't be enough outstanding votes for us to be able to win Ohio. And therefore, we cannot win this election.
were stunned. John Kerry had promised to challenge the machines and amassed a network of lawyers to protect the votes. And then, Kerry stopped any investigation by conceding, less than 12 hours after the polls had closed. Cliff Arnebeck, an Ohio election attorney, spoke with John Kerry shortly after.
The call from Senator Kerry comes into the hotel room, which a group of us are there meeting with Reverend Jackson. Reverend Jackson puts his phone on the table, hits speaker, and we're now in a conversation. The first part of the conversation is a dialogue between counsel and Kerry. Part of that dialogue includes Kerry sharing the fact that in New Mexico, no matter what the demographics of the jurisdiction are, if the votes are being counted by optical scan machines, they're coming out for Bush. This is, to anyone who's familiar with the situation, this means Kerry knows there's fraud in that election.
And the optical scan machines are the clue?
Yeah, what he's saying is that it's the optical scan machines are being rigged to produce a result for Bush.
Place a mechanism for deciding what is unacceptably poor, not up to snuff. It is not permissible without a better reason than mere coincidence and the serendipity of timing and the accident of geography to use that method, which is deemed deficient by the state itself and which will be phased out in March of 2004, when there are available methods that the Secretary of State has found acceptable. And
even if those methods, however, as you discussed before with Judge Tashima, might not be
perfect
as acceptable, and nobody suggests anything should be perfect in the electoral world, but that there will still be inherent errors in those, particularly in those counties that don't have the precinct scanning. So how do you then distinguish between the punch card ballot, which has some error in it, which is, I think, agreed by the state, and the error which will also be inherent in the new scan?
Take unto itself the task of second-guessing the determination of the responsible state officials as to which of these methods, though all of them have some errors, which of these methods are understood to be so rife with inherent problems that they are unacceptable and which are not.
Counsel, I have a couple of problems with what you're saying. The first is the core of your argument seems to be that Bush v. Gore should be extended to this case. There's a sentence.
Excuse me, Judge Kleinfeld.
I read the brief.
I understand, but extended is a word that I think this case is simpler than Bush v. Gore.
Let me ask you a question about Bush v. Gore. There's a sentence in it that appears to me to expressly distinguish this case. The court wrote, quote, "The question before the court is not whether local entities, in the exercise of their expertise, may develop different systems for implementing elections," close quote. There, the Supreme Court seems to recognize that different localities within states may have different voting systems, and they expressly distinguish and limit Bush v. Gore in that decision. Not
Judge Kleinfeld, I'm glad you focus on that language, because it seems to me that one of the four facets of Bush v. Gore that we think is quite uncontroversial and that we happily embrace is the fact that the favorable view of decentralized small government with play in the joints, with local entities exercising their own expertise, that was expressed in that opinion, does not extend under Bush v. Gore itself, and that was the whole point of the preceding and following paragraphs, does not extend to decisions about how and when the conduct of a statewide count of ballots under one supervisory authority